Hello and welcome to everybody viewing us from all over the world. Thank you so much for once again supporting and viewing our conversations with the one and only Attorney Sharif Silmi of Silmi Law. Hi, Attorney Sharif.
Hello, Mary. Thank you. Thanks. Appreciate it. It's a great opportunity. Lots of news changes and excited to have this conversation. Hopefully we could clear the air.
Yes, and I'm sure many of our friends and even our existing clients are very excited to hear it straight from Attorney Sharif Silmi. So let's get started. So basically, it's two things. First would be the newly released fiscal year 2024 October Bulletin and the policy manual. So Attorney Sharif, your take on these two things, starting maybe with the October Bulletin for 2024.
Sure. I'd like to just share our screen here because I think that the first thing we'd like to do is to take a look at the bulletin that everybody I know has been crashing the website of. And you can see here that the bulletin is such that they listed according to the month, obviously, right? Visa Bulletin for October 2023. And note that this is a State Department issued bulletin, right? So U.S. Department of State's issuing the bulletin. And we don't need to look very far. We just need to go to the second paragraph. And there's very important language here. And what it says is that essentially, unless otherwise indicated on the U.S. Citizenship and Immigration Services website, right? And here's the website. I highlighted it. This is the website, right? Individuals seeking to file applications for adjustment of status with USCIS must use the final action dates. Now, somehow, everybody reads that to interpret it as only the final action dates matter. But that's not what this is saying. What this is saying is, unless otherwise indicated on the U.S. Citizenship and Immigration Services website, then you should use the final action dates. So if I say, unless you have a permission slip to go to the cafeteria at school, stay in your seat, right? So if you actually are given a permission slip, does it mean that you can go to the cafeteria or does it mean that you have to stay in your seat?
I know. Yeah. So
okay. You can go to the cafeteria. Why? Because you have a permission slip. Okay. So here, this is our permission slip right here. USCIS.gov Visa Bulletin info. All right. So we go to this website. You know what? I already have it open. Okay. So actually, I do not. I lied. Okay, so we're going to go to this website. And when we go to this website, this is the adjustment of status filing charts. Now, while it is based on the Visa Bulletin, USCIS will determine how and when and, whether you're able to use final action date or filing date. And essentially, what happens on this website is determinative. The USCIS adjudicator who's going to accept an I-485 adjustment of status case does not give a damn about what's on the State Department website. The only thing they care about is what is on the USCIS adjustment of status filing chart bulletin. So if we go ahead.
It's your permission slip, in essence.
It's your permission slip. There you go. Now, I completely understand that, many folks will be confused by this because it is, really, really confusing. But
yeah,
each and every month, it could change. Now, for this month, right? Actually, let's look at last month. So last month, what did it say? It said for all employment-based categories, you must use the final action date chart, right? Now, that's last month. That's September. Or the current month, I should say, right? But for October Bulletin, right, which was highly anticipated, we're looking at October Bulletin. It doesn't say that you must use the dates. It just says you must use the dates for filing chart, right? So that means that, Okay, I'll repeat it again. Ready? For all employment-based categories, you must use the dates for filing chart, not the final action dates. You must use the dates for filing chart. So what that means is that we are actually going to use the October dates for filing. We're not going to use the dates for final action date. So the USCIS October 2023 adjustment of status filing charts. This is when to file, right?
Yes.
First category, employment-based immigration. Dates for filing for employment-based adjustment of status, India, July 1st, 2019. It's not June 2017. I promise you. It is July 1st, 2019. Dates for filing for employment-based adjustment of status. AJ, you owe me $1 million. July 1st, 2019, right here. First category, India. First category, current for all other countries. Okay. Now, our friends who are filing national interest waiver, right? We're looking at second category, all countries, January 1st, 2023. All right. January 1st, 2023. So your national interest waiver, second category, EB2 NIW, adjustment of status date is January 1st, 2023. And again, India, second category is not looking too good. May 15, 2012, right? So the point being that when it comes to adjustment of status filing, you do not just go with the visa bulletin final action date blindly, right? You go with final action date if the USCIS does not indicate that you go with filing date. But in this situation, in October 2023, it says very, very clearly that the dates for filing of employment-based adjustment of status are going to be July 1st, 2019, which is essentially the filing date under the State Department Bulletin, right? So we don't care about the final action dates for anyone who is physically present in the United States and intending to adjust status. We only care about these dates right here.
Okay.
All right. So I want everybody to just please look at the uscis.gov visa bulletin info page. That'll take you here. When to file your adjustment of status application for, so this is for family or employment-based preference, 2023, October. When to file. Here we go. First category, July 1st, 2019. Second category, January 1st, 2023. I have explained this probably 30 to 40 times in the past 3-4 days. And I hope that this clears it up and that folks can understand what the filing chart is saying. Essentially, adjustment of status is going to be based on the dates. I don't even want to say adjustment of status is based on filing date. What I want to say is adjustment of status is based on the published date that USCIS puts out for the date of adjustment of status. So this determines when you are able to file your adjustment of status. It is this chart here, and we should probably, share this link, I guess, with folks. So I'll make sure that, we put it out there. Actually, I can try to put it in the, comments or, somewhere for us to make sure that folks are able to, have that information. So posting it now. So it's
just
gonna
like just to maybe like something like of an example, Sharif. Like for example, I'm an Indian national and I had my approved I-140 like an employer-sponsored different category, right? Sorry, a different, not EB1A. So let's say I had an NIW approved back in, let's say, June of 2019.
Mhm.
I mean, sorry, it was filed, right? It doesn't matter like when the final action or when it was approved, as long as it was filed before July 2019. That's what you mean, right?
That's correct. So, for example, many folks from India, they'll have a priority date that is based on their EB2
Mm-hmm.
or EB3 employment-based filing. So their company sponsored their I-140 a while back, and then that would set a priority date for them. So, for example, if somebody had a priority date in 2018, that's when their original I-140 EB2 was sponsored, and then now they get a EB1A approved. They're able to file their adjustment of status in October based on the filing chart, which says July 2019. So Sandeep has a question. He said, so if EB1A approved now, if priority date is prior to July 2019, can we get EAD and advanced parole, or do we need to wait for final action date? You could get a green card. Your
Yeah.
date is before July 1st, 2019. It
Mhm.
means you can adjust status.
Yes.
And yes, you file for I-485 adjustment of status. You file for I-765 employment authorization document. You file for I-131 travel document. So I don't know how much more clearly I could state it, but that's the issue. Emily said it's crazy that Indian national at the top of her field, best in the world, has to wait 7-8 years on a green card. Yes, I know it's very crazy. We all know that it's crazy. It's been crazy for a very long time.
Yeah.
First time in years, October bulletin for EB2 is not current. Bad news. It's bad news for everybody. I agree. But at the same time, I mean, it's better news if you have an EB1 than if you don't, because the date for green card adjustment of status is July 1st, 2019, whereas for EB2 and EB3, it is May 2012.
Wow. Yeah.
And we know that there are millions of people in between, and that date's not going to move very fast. So that's the situation with respect to the visa bulletin. And I posted the link on the YouTube channel comments in terms of, how you actually access the correct bulletin, which is the USCIS adjustment of status bulletin. So dates for filing employment-based adjustment of status, AOS, adjustment of status. That's the application that takes you from a non-immigrant or, maybe temporary worker to a, green card holder, right?
Mhm.
So that's what we're talking about here. And so that should be very, very clear now. Any questions from any of the other platforms or that you have, Mary, that any of the folks are sending you directly?
Well, yeah, so that's good news. And many of our clients are also asking about the other good news that you mentioned as well. Yeah, but we'll get to that in a while about the policy manual. So what is it?
Yes, sure. No, yeah, no, I can get to that even now. I think, so just to be clear, I mean, look, it's not, I don't want to say it is, very good news as far as the, dates are concerned for the visa bulletin. It's quite clear that the dates have not advanced as much as people have hoped. And I think that we're probably going to see a lot of demand in the first category for India, increasing more. I mean, I've seen it on my side. We've been able to get lots of cases approved, and that's certainly, putting pressure there. At the same time, I think that we are, seeing EB2 having pressure in the non-India categories. So, those employment-based categories are definitely getting lots of pressure. So there used to be like a pour over of additional availability of visas from other categories, like family-based categories that were going unused. And that has not been the case the past couple years. So, we're seeing a little bit tightening of availability. and that's certainly impacting the information. Sandeep said, thanks, hope USCIS reads same way as we do.
I
I
just have
mean,
like
look, this is not an option. Like, maybe whoever's providing the documentation is not doing so in a clear manner, but this is not a, like either or perhaps or maybe. This is a very clear dates. You're entitled to these dates. There's statutory bases for the use of these dates as presented here. So this is not my opinion. These are facts. So perhaps you need to, just kind of reach out, have things provided in the best possible way. But yeah, there's not a hope here. There's and I think part of the reason why many people hesitate or get into trouble is because, they're just hoping or asking, depending upon the government's goodwill. You don't depend or hope, you demand, and you pursue what is your legal right. I mean, when an administrative agency puts out specific dates, and it literally says dates for filing for employment-based adjustment of status, that's the date for filing employment-based adjustment of status. There's no other way around it. So you are able to use that to your advantage. So I want to make sure that everybody's very, very clear on this point, and that you understand that the dates for filing your adjustment of status, for if you're physically present in the United States, is July 1st, 2019. If your priority date precedes July 1st, 2019, then you're able to file for adjustment of status. There are some instances where your subsequent EB1 approval date, priority date, is not, your previous priority date is not indicated on your form or on your approval notice of your EB1 for whatever reason. Maybe you guys didn't submit it, or perhaps the USCIS officer made a mistake. That does not impact your ability to adjust status, because statutorily they have to honor your previous I-140 priority date. So you would just have to submit your previous 797 approval notice plus your newly approved 797 approval notice together and claim your previous priority date, and it will be honored. So that's the one thing that I would just put out there as a caveat. But again, there's absolutely no doubt whatsoever that the date for filing for adjustment of status in the month of October is July 1st, 2019 for India, and January 1st, 2023 for second category. All other countries, for example, NIW and other EB2. And of course, non-India is current. China, August 2022 priority date for adjustment of status. All right.
Yeah, so Sharif, I just have a quick question from a friend. So, Attorney Sharif, who dictates this, the retrogression? Is it because the other countries hit a cap while other countries don't?
Yeah, so there are basically allocation of visa availability for every country, and it's equal allocation, regardless of the size of the country or the number of immigrants seeking to enter the U.S. Of course, that makes absolutely no sense given the demand that exists from countries such as India and China. But unfortunately, that's the reality that we're faced with. Therefore, what we have to understand is that one is in a situation where, you're going to have a lot of pressure on the high population countries. I actually predict over the next maybe 3 to 5 years, we're going to start to see Nigeria appear on the country list, because they're starting. Yeah, there's a lot of immigration coming from Nigeria, and they're probably going to surpass their quota and the employment-based immigration side. So anybody from India, China, obviously you're already in that situation, and we're going to see that pressure starting to increase from other countries. So that's the situation. And of course, we see Philippines up there as well. So check this out. So Philippines is kind of following all other countries as it relates to EB2. But you notice the EB3 dates 1 month retrogressed for Philippines, which is kind of interesting. But
Mm-hmm.
I think that probably relates to, a lot of medical healthcare workers. So there's a slightly higher demand on Philippines than there are on all other countries. So that's sort of an interesting tidbit that we're starting to see there, a slight 1 month difference between Philippines and all other countries. So, things to look out for, but certainly we are, going to keep our eye on this. We'll keep the updates coming on a monthly basis. But anybody who thinks the adjustment of status is 2017, you're just simply misinformed or you're reading the bulletin incorrectly. So that's the situation. So in the case of, I don't understand what
Mano,
this is asking here.
Mano, in the
Yeah.
case of abeyance after I-140 approval, can I still apply for EAD and advanced parole? And what are the conditions if your priority date is not current?
Yeah. So if your priority date is not current, then you're not able to apply for adjustment of status or for EAD, employment authorization, or travel. You have to maintain other status until your date becomes current. So you can maintain other status such as a F1 student, as a H1B, temporary worker visa. What the I-140 approval does do for you, though, is it allows you to renew your H1B past the statutory limitation of 6 years until your date becomes current. So normally an H1B can only be is extended for 3 years, and you have 1 3-year renewal. But if you have a I-140 approval, such as a national interest waiver, then you can renew that H1B for in perpetuity, at least until your dates for adjustment of status become current. So that's the situation. We have, I think, maybe about 8 minutes. I don't know. Do you think we're clear on adjustment of status, or do we want to maybe shift over to the news regarding the policy manual?
Attorney Sharif, before we do that, just to clarify, H1B, but they have to be with the same employer, right? Before they can, even if they have an approved I-140.
So if they have an approved I-140, no, they could, a subsequent employer can also file
Okay.
well, because in that scenario, their I-140 would be based on self-petition, such as a national interest waiver or an EB1A, and it doesn't matter who their employer is at that time because their approval is not dependent upon a job offer. So that's one of the beauties regarding the
Having
the situation. Exactly.
Okay, thank you so much for that, Sharif. So moving
Absolutely.
on to the policy manual. Then
Sure.
excited
So
to hear about it.
absolutely, yeah. So moving on to the policy manual, the USCIS policy manual is what the adjudicators have to refer to in, looking at a petition. And for the most part, there's not many changes here. It used to be that the extraordinary ability criteria, that is the regulatory criteria, would come in the appendix section,
Mhm.
and they shifted away from that a bit. So essentially, what happens now is here you have your statutory requirements, which is that you demonstrate that you have sustained national and international acclaim that is recognized in your area of endeavor, that you'll continue to work in the area that you have been recognized in,
Mhm.
and that you are remaining or entering the United States to substantially benefit the US, right? Those are the 3 statutory requirements.
Mhm.
Now, what happens is most people tend to focus on the regulatory criteria, which I think could be to their detriment. You don't always want to look only to the regulatory criteria, but inevitably that's what happens. Now, there are essentially some of the examples of when, considerations and examples related to STEM field have been added into the adjudicators manual. I think mostly everything here is positive. Even like the membership criteria, I feel like was loosened up a bit. And, we see, like, for example, here it says relevant factors that may lead to a conclusion that a person's membership was not based on outstanding achievement would be level of education, payment for a fee, and a requirement that they're a member of an organization in order to undertake some professional activities, such as being a member of like an engineering board, right? So if your membership is like, I'm a member of the, Texas Board of Engineers, right? That does not help you establish this regulatory criteria.
Wow.
So, yeah, because that's a membership that's required in order to practice the profession. If you pay a fee for a membership, that's usually an indication that it's not something that's benefiting you from a recognition perspective.
Because
If
basically
it,
anybody can pay a fee,
because
right?
anybody can pay a fee, exactly. If it's based on a level of education, that's not sufficient, because no level of education can establish approval or qualification for EB1A, and no lack of education can interfere with one's ability to acquire EB1A. All right. And the really, really important, I mean, I've actually handled cases for people who have no college education whatsoever, and we've been able to get those cases approved. So there is this point that is very, very important. But what I was going to say with regard to membership is, so then if these are the things that result in a conclusion that your membership does not qualify, then the absence of them would be evidence that you do qualify. So I think actually it is, there are some things in here that we can use to really argue forcefully on behalf of people. So I'm looking at this with really a broadened ability to even have approval of EB1A expanded beyond where we already have expanded it to. One other area where I think there is a significant difference is in salary.
Okay.
So the adjudicators have always been quite strict about making sure that you're basing your salary on established tax return or W-2. And here it opens up the evidence relevant to demonstrating high salary to contracts, job offer letters, and other evidence of prospective salary.
Okay.
So
Meaning like job
prospective
offer?
salary means that you haven't yet earned it. So essentially, it could be a job offer. It could be, something where this is what we anticipate they will be earning. And that is new. That was not there before. So that, I think, is the biggest difference. Salaries much more, I think, is opened up greatly here. And I feel like this is really going to be a game changer for a lot of people. One more thing about salary that I found very, very promising is the language that was added to the very end here, which says, for entrepreneurs or founders of startup businesses, officers consider evidence that the business has received significant funding from government entities, venture capitalist funds, angel investors, or other such funders in evaluating the credibility of submitted contracts, job offer letters, or other evidence of prospective salary or remuneration of services. Essentially, what that means is that one who is, for example, a CTO or a COO or even a CEO of a startup, and they have some, investment and have made a valuation based upon investment, then their equity share of that organization can be calculated as remuneration for services. So if you have a startup that you've been involved in, let's say for 2 years, and you received some funding, and that funding was, let's say $1 million for, a valuation, and you own 75% of the company, right? So then you've just earned $750,000 according to a remuneration analysis, right? So, long story short, I do think that the policy changes are positive and do allow us to kind of further support STEM and technology related contributors to qualify for the regulatory criteria. So I think overall, I was very positive on the policy changes there.
That's wonderful to hear. Oh, one more thing, Sharif. So I think that's very positive, and it kind of reminds me of like NIW. It kind of overlaps in that sense, right? When you have like an endeavor wherein the government or other entities give you grants, I think
Yeah,
that's very, very
it's
positive.
I agree. I think it is interesting. They did kind of borrow from the NIW because the idea of the EB1A being something that you can show prospective evidence of is new. That's not something
Yeah,
that it was always that you have to already have demonstrated evidence of achieving some specific thing. Now, I would venture to guess that these changes are probably going to only be in place for 2024
yeah.
because
Hmm.
if well, it depends on what happens obviously with the elections, but if you have a Republican or a more conservative government, particularly a Trump like USCIS director, then a lot of these policy changes that are like helpful to people are going to be rescinded. So this is a window of opportunity, I would suggest.
That's wonderful. But then, sorry, just to be clear, prospective, but you still have to submit evidence. Like, I mean, the traditional, I mean, the earlier ones, right?
Of
It's not
course.
just,
I mean, you have to still have some kind of contract, right?
yeah.
It's just that that contract could be for future services.
I understand. That's wonderful news, and thank you for clarifying and sharing that, Sharif. Otherwise, we don't really read the small print, right? One last thing before we let Attorney Sharif go, and we have like people waiting on him. One last, Attorney Sharif. Can an F1 visa holder travel outside of the USA and renew the visa even after filing EB2 NIW I-140 or approval of the I-140?
I don't think so. I mean, I think that that's a highly risky strategy because a F1 visa is a sole non-immigrant visa, and trying to re-enter on an F1 after having already received approval of an immigrant visa means that your entry would likely be with the intent to immigrate. Therefore, a consulate officer could deny your F1, or a CBP, a Custom Border Protection officer, could also deny you entry, and it's a risky strategy. If you are going to try it, I would try going to the American House, which is at the U.S. border, and try to renew your F1 visa there, because it counts as an exit entry, and you don't actually have to physically leave the U.S. So if they turn you down, then you're still physically in the U.S.
Okay, because the F1 is not a dual intent visa, right? I mean,
Exactly.
it's just for
Exactly. Yeah. So
non-immigrant.
if it was like an H1B or an O1A, you wouldn't have that problem.
Okay, so I think we have to wrap up because like I have three people to call right after this, Attorney Sharif, and we'd just like to mention Mr. Ramana Miryala. Thank you for watching. He said, "Thank you so much, Attorney Sharif, for the detailed information. Thank you for trusting Attorney Sharif, of course, and of course everybody else who would like to consult with Attorney Sharif. You know what to do. You can call us, or you can simply book your own consultation at www.silmilaw.com. You can see it on the screen. So thank you so much, Attorney Sharif.
Exactly. Yeah, we want to strengthen people out there. I think a lot of people have really great like profiles and great stories to tell. You just need someone to really tell it in a very forceful and direct and aggressive fashion. So hopefully we could do that for more people out there. Have a
Yes,
wonderful evening,
and like
everyone.
what Attorney Sharif says, take matters into your own hands and call us soon. Thank you so much, Attorney Sharif. Thank you so much, everybody. See you next time.
Thank you. Bye bye.